The Center for African Peace, Justice and Human Rights is the organizer of today's event, and we are very excited to welcome you all and engage with the discussions and arguments that are going to be presented by the debating team. I now extend a particular and special invitation to Ana Chiara Di Domenico, the legal researcher from the capacity building team and one of the organizers of this debate, to deliver a keynote speech on behalf of Mrs. Sophia Ugwu, the center's founder. She will be introducing the organization and its work.
Thank you very much. Good morning, distinguished guests, esteemed judges, dedicated coaches, and above all, our brilliant students. This is a message from the Center's founder, Sophia Ugwu. We are delighted to welcome you to the third edition of the Center for African Justice, Peace and Human Rights Legal Debate Project. At the Center for African Justice, Peace and Human Rights, we believe in the transformative power of education, dialogue, and critical thinking. Through initiatives like this debate, we give students not only the opportunity to refine their advocacy skills, but also to apply international law to pressing global questions. This is where theory meets practice and where the next generation of legal minds begins to shape the future. Today's motion, plea bargaining in international criminal justice, a clog in the wheel of justice, is not just an abstract legal question. It touches on profound issues of fairness, efficiency, accountability, and the very pursuit of justice in post-conflict societies. The arguments you will hear today reflect the challenges real practitioners and policymakers deal with in courts and tribunals around the world. As you may already know, plea bargaining has both strengths and weaknesses. This debate brings this duality into focus and invites us to consider not only how such agreements can benefit criminal justice systems, but also how their outcomes may be perceived by victims and witnesses in conflict-affected settings. On one hand, plea bargaining offers clear benefits to international criminal justice. It increases efficiency by reducing the length and cost of trials, allowing courts to focus on the gravest crimes. It provides a degree of certainty for both prosecution and defense, and it may encourage perpetrators to cooperate by offering information that helps bring higher ranking officials to account. Plea bargaining also secure convictions for specific crimes and can spare witnesses the re-traumatization of testifying. Beyond these practical gains, plea bargaining can even contribute to reconciliation processes, offering victims a sense of justice and closure and supporting broader post-conflict recovery. On the other hand, there are clear disadvantages to plea bargaining in international criminal justice. It has been argued that it may undermine the pursuit of full accountability, as perpetrators can secure lighter sentences or reduced charges, creating perception of impunity and weakened deterrence. Research shows that victims and affected communities often feel dissatisfied with such outcomes, believing that plea bargaining diminish their role in the justice process and fail to fully establish the truth of events. In some instances, perpetrators who admitted guilt under plea agreements later deny responsibility, undermining reconciliation and the credibility of justice systems. Moreover, shortened proceedings risk limiting the historical record of atrocities, while the secrecy surrounding negotiation can fuel mistrust in the transparency and legitimacy of international tribunals. We are eager to see how our debaters will navigate these competing arguments around plea bargaining, balancing its promises of efficiency and reconciliation against the risks of diminished accountability and justice as they defend their positions. Our vision at the Center has always been to nurture a new generation of international lawyers and equip them with knowledge, courage, creativity, and deep commitment to human rights. By participating in this debate, you are part of that vision. You are building bridges across borders, engaging with diverse perspectives, and strengthening the rule of law. To the students debating today, I encourage you to speak with with conviction, listen to with openness, and embrace this as a chance to grow. To our coaches and judges, thank you for your generosity to share your expertise and helping us shape our platform. And please also allow me to extend a heartfelt thank you to our center's capacity building team for organizing this debate. Your dedication, commitment, and tireless efforts have made today possible, and we're truly grateful for the work they do in shaping future legal minds. To ensure to everyone joining us virtually from around the world, a very warm welcome. I encourage you not only to enjoy this debate, but also to take away insights that may strengthen your own practice, whether at international or domestic level of criminal law. And finally, I wish to thank the board and management of the Center for African Justice, Peace and Human Rights for creating this platform for academic engagement, dialogue, and growth. Without their vision and support, initiatives like this one would not be possible. May today's debate inspire all of us to think critically, argue passionately, and above all, remain committed to the ideals of justice, peace, and human rights. Thank you, and let us begin.
Thank you so much, Anikara, for that warm welcome and introduction into the working of the organization and the capacity building team. As you all know, we are here today to watch the legal debate pertaining to the motion, plea bargaining in international criminal justice, a clog in the wheel of justice. The judges for the debate today are three exceptional lawyers and academic notable in the international law field. On the panel, we have Judge Ariet Sali, Judge Abiodun Ashiru, and Judge Jean-Yves Ndanza. Mrs. Ariet Sali is a registered of the Supreme Court of Uganda within 23 years of legal and judicial experience in international criminal law. Mr. Abiodun Ashiru is a lecturer at the Department of Public and Private Law of the Lagos State of University and PhD candidate, currently at the University of Lagos, where he is focusing on plea bargaining as an integral part of the criminal justice system across different jurisdictions. Dr. Jean-Yves Ndanza is a junior diplomat, scholar, and practitioner in international security, international humanitarian law, strategic studies, and diplomacy. And on the behalf of the Center for African Peace, Justice, and Human Rights, I want to thank you for taking the time to be present today with us, and we are extremely honored to have you all judge this debate. So today's debate timekeeper is Alexandra Titrishi. She is a member of the Center Capacity Building team and will be responsible for tracking the speaker's time. So today's speaker for the proposition team representing King Caesar University are, may you excuse me for the mispronunciation of name, Namwija Koni, Numayonya Ignatius, Kyo Shabir McLean, and the speaker for the opposing team representing Alliance University are Kushi Tripathi, Ganesh Vajrapu, Jishu Venkataraman. So I would like to, as Annika just said earlier, thank the coaches. I would be remiss not to acknowledge the coaches that ensured that the teams are well prepared for this event. Firstly, we'd like to thank Dr. Raja Banerjee. Dr. Banerjee is an associate professor from Alliance University with almost 20 years of experience in teaching and research on constitutional law, public international law, and international criminal law, and more. Additionally, we would like to thank Reverend Consul Samson Malisa, who is a lecturer at King Caesar University and a legal associate at Kitimbo Associate Advocates with over a decade of experience in the academic and legal environment. Thank you so much, Dr. Raja Banerjee and the Reverend Consul Samson Malisa. Although your face will not be seen on screen today, your work will shine through the debaters here today. So before we get into the debate, let me explain the structure of the event, after which we will move immediately to the debate, starting with the first speaker of the proposition. So the debate will end in approximately an hour, after which the judges will have 15 minutes to deliberate. When that time is over, the judges will return to the virtual room, provide their feedback to the participants, and announce the winner. In case the judges are finished sooner, they are welcome to come back to the session right after they finish. After that, Ms. Adosela, the executive director of the center, will give the closing remarks. The rules and procedures of the debate have already been sent to both of the debating teams, coaches, and judges prior to the debate. But as a reminder, each speaker will be allotted a time of 10 minutes. The remaining minutes they have will be visible on the screen, and we implore each participant not to exceed their given time limits. The participant will be judged according to a marking criteria, where they're assessed according to the content, substance of their arguments, presentation skills, and their overall impressions. A warm welcome to all the participants of the debate, and best of luck for both of the teams.
Ines, I think you can also start announcing the first speaker.
Okay, sure. So now I welcome Nyaninja Kani, the first speaker of the proposition team, to open the debate. Go ahead.
The Honorable Chair, esteemed judges, affirmatives and negators, and the audience. My name is Nyamuja Koni, a student at King Caesar University. Today we are debating the motion, plea bargaining in international criminal justice, a clog in the wheel of justice. Together with me is the affirmative team with Chosharire Macklin and Ignatius Nwamai. And as affirmatives, our answer is definitely no, and we strongly support the use of plea bargaining in international criminal justice. Let me begin by defining the key terms. Plea bargaining refers to the legal process where the accused agrees to plead guilty to a lesser charge or to multiple charges in exchange for some concessions, such as a lighter sentence or the dropping of other charges. International criminal justice, on the other hand, refers to the legal mechanism, like the International Criminal Court, that prosecutes individuals for serious international crimes, including genocide, crimes against humanity, crimes of war, and crimes of aggression. A clog in the wheel of justice, in this instance, refers to an obstacle that hinders the efficient functioning of the legal system. My teammates will address potential concerns such as fairness and legitimacy and show how they can be mitigated. Today's motion is very relevant and worth debating. International tribunal and the ICC face enormous backlog, limited resources, and complex cases involving mass atrocities. And this is why plea bargaining has been increasingly discussed as a practical tool to deliver justice more efficiently while ensuring cooperation from perpetrators. So what happens in plea bargaining? Basically, the accused, represented by his lawyer, negotiates with the prosecutor to reach an agreement. And the agreement is that the accused is going to plead guilty, and the prosecution in return may offer some concessions, such as reducing the severity of the case and also recommending a lighter sentence or dismissing some of the charges. Thus, plea bargaining gives voice to individuals. It should also be noted that plea bargaining requires court approval, and it is a voluntary agreement, and both parties must have understood the terms of the agreement. This is why we believe that plea bargaining, when used responsibly, can strengthen international justice. In the case of Santobello versus New York, Justice Berger, that is the case of 1971, described plea bargaining as an essential component of administration of justice and a highly desirable part of the process. So let's all note that international criminal law has only one court, and that court is the ICC. This court was established in 2002 under the Article 25 of the Rome Statute with the aim of investigating and prosecuting grave crimes, serve as a permanent institution, and also promote peace and justice, as well as promoting peace and security. This one court is situated in Hague, in Netherlands. It is also important to note that there are 125 countries that are parties to the Rome Statute, and these countries have ratified it. So they have ratified the treaty, that established the court and committed themselves to be part of it. And the question is, so what about other countries that are not part? Are we saying that the ICC is only allowed to try only 125 countries? And because of this, the ICC has found itself in difficult situations, especially when trying to try suspects from countries that are not parties to the Rome Statute. For example, the former president of the ICC of Sudan, that is Omar al-Bashir, is still at large since 2009, when the first arrest warrant was issued by the ICC, and the second arrest warrant was issued in 2010, still on 5 counts of murder, rape, crimes against humanity, among others. But since then, Bashir has never been arrested by the ICC, since the ICC does not try individuals when they're not in court. More so, Sudan also claims that since they're not parties to the Rome Statute, there's no way the ICC can try their members. The structure of the ICC also is very difficult to deliver justice in time. Imagine how much money will be used to transport someone, for example, Bashir from Sudan to Netherlands, to be tried. It will consider how many days it will take to successfully do that. Some people will give up when justice is delayed. And such processes drain resources, delay justice, and overwhelm victims and witnesses. The rigorous procedure also is problematic. The trial process takes 3 stages. Imagine how many days it will take to go through all these stages. For example, the ICTY, which is the International Criminal Tribunal for the former Yugoslavia trial of the Radovan Karadzic, lasted over 8 years with thousands of documents and hundreds of witnesses. Imagine if you're the party in this case, would you wait for all this long? And the ICC also makes it very difficult to select ringleaders. In most cases, the ICC arrests 2 or more persons, accusing them of crimes of genocide, war crimes, among others. But remember, these are the crimes that are committed by a large group of people or a gang. So are we saying that if we arrest 1 or 2 of the members, the rest are innocent? So there's definitely a problem here. And in most cases, the persons who are arrested are just pawns, are not the ones who have committed the crime. Also, it will be a joke to think that one court can possibly handle cases of 125 countries who are parties. And this is where the court gets overwhelmed by case backlogs. Remember, due to this, at first, the ICC had barred plea bargaining from its court because they were claiming that plea bargaining does not fit their goal of justice. They were claiming that because the international crimes that are committed do not require negotiations. But then, since they are overwhelmed by the case backlog, they decided to employ plea bargaining again. What does this mean? This means that we cannot rule out the fact that the ICC needs assistance, and this assistance can only be done when plea bargaining is employed. In the case of prosecutor versus Obrenovic, the case of 2003, the victim, Emmaus Aljiki, said that plea bargaining entered into by the accused persons, and their confession brought him a sense of relief that he had not felt since 1995, and they gave him the acknowledgement he has been looking for the past 8 years. And therefore, we argue that plea bargaining is not a cloak, but rather a pragmatic mechanism that ensures timely justice, helps establish truth and accountability, respect victims through quick acknowledgement and reparations, and strengthens rather than weakens the international justice. Imagine when you look at what is happening in Israel right now, one wonders whether the ICC has left its powers, the superior states, to punish the weaker states or even punish international offenders. Recently, it was reported how Israel attacked a hotel in Doha where the suspects of Hamas terrorists were meeting, and they destroyed civilian property. So the question is, where is the ICC? I want to believe that the silence of the ICC clearly shows that there's a lot of case backlog and the ICC has nowhere to start from. So that's why we need to welcome and embrace cheaper, simpler, and more efficient methods to solve these cases. In conclusion, plea bargaining in international criminal justice is not a flaw in the system. It is a tool that recognizes the complexity of global justice and need of both efficiency and accountability. It does not clog the wheel, rather it helps it turn. We proudly affirm that plea bargaining is valuable and legitimate part of the ICJ. I beg to submit. Thank you for listening.
Thank you so much, Namija Kauni, for such an insightful speech. Now, I would like to call Kushi Tripathi as the first speaker for the opposition team to give the opening speech for their team.
Before beginning my speech, I would like to clarify that we might pronounce some names wrong, so apologies in advance.
No worries. Also, I'm sorry for all the mispronunciation of names.
And also, please begin the timer on the countdown of 3. Thank you. Distinguished judges, esteemed affirmatives, and fellow debaters, I, Kushi Tripathi, the first speaker from the side negators, wish a very warm welcome to all. I'll be beginning my speech in 3, 2, and 1. The very essence of this debate lies in the motion, plea bargaining in international criminal justice, a clog in the wheel of justice. I am here to argue the contrary. The International Criminal Court was established not just to punish, but to deliver a credible, impartial, and enduring record of humanity's gravest crimes. Plea bargaining, however, undermines this mission. Though hailed as efficient, it erodes truth seeking, coerces defendants, diminishes victims' voices, and threatens the ICC's legitimacy. I'll be clarifying the burdens on the both sides. The burden on the proposition and the opposition is twofold. As we, as the side of opposition, would like to define a clog as obstruction to justice or a method of obtaining it that is not justifiable in and or of itself. Primarily, we would like to elaborate upon what plea bargain means and how it is very different from admission of guilt. Moving forward, an admission of guilt is a voluntary statement by an accused accepting responsibility for charges without necessarily including any bargain or concession. The accused admits to the guilt, but there is no deal with the prosecutor. The prosecutor simply verifies the factual basis of the charges. There is no negotiation. A plea bargain, on the other hand, is admission of guilt with negotiation. A plea bargain refers to a negotiated agreement between the prosecutor and the accused, where the accused agrees to plead guilty in exchange for concessions. It is fundamentally a product of negotiation. The prosecutor actively negotiates and may agree to amend charges, recommend sentence reductions, or drop counts. As side negators, we contend that plea bargain does not meet the goals of international criminal law as propounded by renowned academic Regina Rock's law, which are namely 1. Replace impunity with accountability. 2. Break the internal cycle of ethnic violence. 3. Facilitate reconciliation. And 4th, which is last, bring perpetrators to justice in a fair trial, thus restoring the rule of law. With reference to Security Council Resolution 808, paragraphs 5 and 6, while establishing the ad hoc tribunals, the Council made it absolutely clear that these institutions were created to open court, put an end to such crimes, to bring perpetrators to justice, and to contribute to restoration and maintenance of peace. Close quote. The key objective of ICTY is to try those individuals most responsible for appalling acts such as murder, torture, rape, enslavement, destruction of property, and other crimes listed in the tribunal statute. We contend that plea bargaining is not legally compatible with the current ICL framework. This will be proved in all of our arguments, which are plea bargain is incompatible with the duty to prosecute and issue proportionate sentences. Plea bargain does not only undermine truth seeking and accountability, but also distorts the historical record of atrocities. Plea bargain fundamentally fails to serve victim centric justice. Plea bargain is structurally inherently coercive. And lastly, plea bargaining is not functional necessity for the ICC. Moving forward to my first assertion, which is dealing with the compatibility of plea bargain, which beginning, the ends do not always justify the means. Plea bargain is fundamentally incompatible with the principles of international criminal law because it prioritizes expediency over justice, allowing negotiated outcomes to replace a full and transparent trial process. In Prosecutor versus Momir Nikolic, the ICTY warned that, open quote, must not compromise a complete and accurate record of crimes, end quote. Yet in practice, charge bargaining often, according to Shaw, has the effect of editing out the factual basis and thus has the potential to distort the historic record, which will be addressed by the subsequent speaker. Langman famously argued that plea bargaining is a coercive shortcut comparable to torture, where confessions are exchanged for leniency rather than truth. Such negotiations also sideline victims' voices, undermining the ICC's mandate under Article 68, Para 3 of the Rome Statute to ensure their participation. Efficiency is no excuse for compromised justice. Articles 64, Para 8 and 65 of the Rome Statute neither contain the term guilty plea nor civil law notion for confessions, but rather use the expression proceeding on an admission of guilt. The wording chosen was mainly a reaction to the rift between the proponents and the opponents of the American style plea bargaining system during the preparatory stages of the court. As Judge Cassisi stressed in his dissent, Prosecutor versus Eridamovich, legal constructs and terms upheld in national law should not be automatically applied in international law. Article 4 and 5 of the Genocide Convention demand its prosecution and punishment. To sacrifice a count of genocide for judicial economy, we contend is appalling. We contend is appalling. Therefore, we argue that plea bargaining is incompatible with the spirit of international treaty. This has been further supported by Prosecutor versus Momir Nikolic sentencing judgment paragraph number 65. According to this paragraph, the trial chamber emphasized that once a charge of genocide has been confirmed, it should not simply be bargained away. I will also make a rebuttal to the claim that that plea bargain facilitates efficiency and expediency, as already spoke up, by my proposition team, citing Bibas and Com's critic, which says that prosecutors use plea leverage to rack up bargaining chips, undermining equality of arms. Only 16% of convictions came via pleas of ICTR. Inconsistent sentencing shows in systems instability. Comparing the Ruggies and Kambanda's case, the ICTR treated guilty pleas inconsistently. Ruggies' plea was mitigating while Kambanda's wasn't. This uncertainty contributes to inherent coercive nature of plea bargaining in ICL, which will be dealt by my subsequent speaker. Therefore, it can be said that plea bargain trades legitimacy for expediency. Moving towards my second assertion, which is plea bargain is incompatible with the duty to prosecute and issue proportionate sentences. The foundational treaties of international criminal law impose a duty to prosecute grave crimes and impose effective proportionate penalties. Plea bargaining directly conflicts with this mandate by allowing prosecutors to drop serious charges and offer lenient sentence in exchange for guilty pleas. Plea bargain undermines full accountability of perpetrators. Would plea bargain really fit with the objectives of international criminal justice? The judges of ICTY firmly answered this in negative. From the very inception of international criminal justice, plea bargain was recognized as fundamentally incompatible with its objectives, as already stated previously in Regina Roxlaw's rule of ICC. In 1994, while officially announcing the rules of procedure that would govern the tribunal, President Antonio Cassisi of the ICTY categorically rejected a proposal to introduce plea bargaining. As he clarified, open quote, this tribunal is not a municipal court, but one that is charged with the task of trying persons accused of the gravest possible of all crimes. The persons appearing before us will be charged with genocide, torture, and other crimes against humanity. After due reflection, we have decided that no one should be immune from prosecution for crimes as these, no matter how useful their testimony is. End quote. This categorical rejection shows that plea bargaining was viewed as a tool for undermining justice for mass atrocities. Can true justice be delivered if offenders receive less than proportionate punishment for the gravest crimes? This question lies in the very heart of evaluating plea bargaining in international criminal law. According to paragraphs 4 and 11 of the preamble of the Rome Statute, the statute emphasizes that the most serious crimes of concern of the international community as whole must not go unpunished, and state parties are resolved to guarantee lasting respect for the enforcement of international justice. Article 76 of the Rome Statute further underscores that a convicted offender must receive a proportionate sentence reflecting the gravity of the crimes committed. Similarly, other major international treaties such as Geneva Convention 1949, the Genocide Convention 1948, and the Torture Convention 1984 mandate proportionate punishment for serious international crimes. While Rome Statute does not explicitly mention proportionate sentencing, this principle is implicit. I repeat, implicit, as disproportionate sentencing are the grounds for appeal for both prosecution and defense. Plea bargaining by reducing charges or sentences principle, potentially allowing serious offenders to end impunity and ensure proportionate punishment, can plea bargain efforts of this purpose? According to these provisions, the answer is clearly no. A limited number of defendants choose to enter guilty pleas, resulting in comparatively lenient sentences. Except for a few cases, life sentences were not imposed and majority received sentences below 15 years. Notably, individuals facing charges both for genocide and crimes against humanity, they were handed sentences for less than 10 years. Hence, a plea bargain is a clear-cut trade-off, excluding the very essence of justice. Therefore, I end my speech by saying that plea bargaining is a wrench thrown in the machinery of justice. I beg to end my arguments, and my colleagues will take it over. Thank you.
Thank you so much, Kushitipati, for your input. I would like to call on you, Nu Wamanya Ignatius, the second speaker of the proposition team, to continue the position of his team. May you excuse me for the misname pronunciation.
Our today's chairperson, the judges, the opposers, and us the affirmatives. Given the challenges that international criminal justice system is facing, we truly advocate for free bargaining in international criminal justice. And our side, we are saying that free bargaining in international criminal justice is not a Clog. And here the arguments as to why we are saying that it is not a Clog because of the perceived benefits that we are having. And the first one is efficiency, and the second one would be the facilitation on the reduction of case backlog, and the third one would be quick relief from anxiety of criminal prosecution as a way of respecting the rights of the accused, and the fourth one would be the accountability as to the taking up responsibility of the crimes committed by the accused, and the fifth would be the ability to have the concerns of the victims and the international community resolved, and the seventh or the sixth would be promotion of alternative dispute resolution at the level of international criminal justice. And here with efficiency, we are saying that pre-bargaining can help manage case loads, and pre-bargaining is centered around the legal process as it reduces the case resolution time, resources required for trials, and this allows courts to manage case loads more effectively and allocate resources to other cases. And here we are saying that this is possible mainly through the cooperation that is provided by the accused in the pre-bargained agreement. Here the prosecutor finds it more valuable, and the accused may provide valuable information or testimony in exchange for the certainty of outcome, and by accepting pre-bargaining, defendants know the exact charges and penalties they face, eliminating the uncertainty of the trial's outcome. And here, having the case of Ara Mahadi, a case where him being accused with the destruction of cultural heritage sites in Timbuktu, Mali, it is a case of 2016. And after entering into a pre-agreement with the office of the prosecutor, we see that him was sentenced to 9 years imprisonment on 27 September based on Article 8 and 25 of the Rome Statute for the attack on the protected objects. And with this, we see that the ICC never spent a lot of time on the adjudication process due to the fact that a pre-agreement was entered into. And our second point, we are looking at pre-bargaining, addressing the victim concerns and the international community concerns. And here we are saying that victims feel their interests are adequately represented in pre-negotiations. And this is mainly achieved due to Article 65 of the Rome Statute, where it is giving expression of the plea of guilt, and under the guidelines, the victims can be contacted for their submissions through their lawyers. And we are saying that their concerns will be addressed. And here we are having a case of Jean Kambanda, a former Prime Minister of Rwanda, who pleaded guilty to the crimes he committed while in office as the Prime Minister. And in this, he pleaded guilty to genocide, conspiracy to commit genocide, and crimes against humanity. And the ICTR recognized his participation and his quick acceptance of guilt, and this resulted into his sentence into a life imprisonment, and that was adequate and satisfactory, which is opposite to the point of the opposers who are saying that it will result into lenient sentencing. And here we are saying that with the case of Jean Kambanda, the one of 1998, we are saying that pre-bargaining indeed addresses the victims' concerns and the concerns of the international community. And for the victims, they are interested in reparations and compensation. And our third point, we are saying that pre-bargaining enhances the historical court record. How? The historical court record, we are seeing that with international criminal justice, a number of cases have already been resolved through pre-bargaining. And to give, we are having Ara Mahadi's case, the 100 by the ICC, the one of Jean Kambanda, 100 by the International Criminal Tribunal for Rwanda, and the one of Drazen Edamovic, the 100 by the International Criminal Tribunal for former Yugoslavia. And with this, we are referencing it, and already the above is achieved due to the fact that rules of procedure and evidence, such as the one of 2015 as amended, the Rome Statute of 1998, and the regulations of the court. With that, I don't think that pre-bargaining undermines the historical court record. Indeed, pre-bargaining has resulted into enhancement of the court record, whereby even the Drazen Edamovic case, we are going to rely on it and say that it almost resulted into a landmark case where we've seen pre-bargaining being accepted after an appeal. And this is what I can quote. The case reassured of the acceptability of the pre-bargaining at ICTY, Edamovic and the prosecution reached a pre-agreement under which he would plead guilty to the offense of war crimes upon approval by the appeals chamber. With that, we are saying that indeed pre-bargaining is not a prong, but rather an accelerator in the way of international criminal justice. And as affirmative, we are saying that in a summarized way, our points, we are saying that pre-bargaining promotes efficiency as it saves time and reduces costs, facilitates reduction of the case backlog, provides quick relief from anxiety of the criminal prosecution, which is a major aim in respecting the rights of the accused. And with justice, we are not only looking at the victims of the crimes or they are chosen, but we are ensuring that we have a fair and transparent criminal justice system whereby rights of the accused are respected. The office of the prosecutor is able to fully exercise their rights and obligations. And with this, indeed, we are saying that free bargaining is not a probe, but rather an accelerator in the way of justice. And we are saying that free bargaining promotes accountability and truth-telling, which is a major aim and concern as it will result into healing and reconciliation. And our major focus on this point, we are referring to the International Criminal Tribunal for Rwanda, while handling the Jean Kambanda's case, where he pleaded guilty to the crimes and he had to accept first that he was in the position where he was trusted with the public trust of having the authority at his disposal, which he misused, that resulted into the genocide that aimed at extermination of the Tutsi community and the attack on the areas of the earth, say the internally displaced people at their camps or stadiums, and with that, the tribunal found it as a mitigating factor to have it resolved. So with that, we are concluding and saying that free bargaining international criminal justice is not a probe, but rather an accelerator in the wheel of international criminal justice. Thank you.
Thank you so much, Numanya Ignatius, for your speech. I would like to call on Ganesh Vajrapu as the second speaker for the opposition team to further the debate for his own team. Go ahead.
Am I audible?
Yeah.
Sorry, just a second. I need to restart the timer.
Sure, go ahead.
Okay. Very good afternoon to the honorable judges, organizers.
Anna, you're muted.
Sorry, just a second. I need to fix the timer. There was some technical issue. Can you hear me?
Yes.
Yeah.
Okay, sorry. I need to fix the timer for a second. I'll let you know when we can start. Hi, sorry. As you may know, there's always some technical issue, but I think we're good to go. Please, Ganesh, let me know when you would like to start.
A very good afternoon to the honorable judges, organizers, fellow debaters, and the audience on live streaming. My name is Ganesh Vajrapu, and I'm the second speaker of side opposition. I'm studying in 3, 2, 1. My colleague has already demonstrated the incompatibility of plea bargaining with the duty to prosecute and issue proportionate sentences. I will now take this further by addressing how plea bargaining not only undermines the truth-seeking and accountability, but also distorts the historical record and fails to contribute to the victim-centric justice. My first assertion: plea bargaining undermines the justice, truth, and historical record. To start, I would like to refer to the objectives of ad hoc tribunals in the deliverance of international criminal justice. With reference to the paragraph 5 and 6 of Security Council Resolution 808 in the year 1993, which was already stated by my colleague, when establishing the ad hoc tribunals, the Council made it absolutely clear that these institutions were created to open court, to put an end to such crimes, to bring perpetrators to justice, and to contribute to the restoration and maintenance of peace. It also declared that these courts have a higher duty, which is search for truth and creation of historical record. End quote. I quote the statement of U.S. Representative. I quote the statement of U.S. Representative Mrs. Madeleine Albright before the UN Security Council. Open quote. Truth is the cornerstone of the rule of law, and it will point towards the individuals, not the perpetrators of war crimes. And it is the only truth that can heal ethnic and religious hatred. End quote. Now, if the truth and the historical record are the very reasons that these courts were established, plea bargaining directly contradicts this purpose and these objectives. My second assertion: plea bargaining minimizes the perpetrator's responsibility by allowing defendants to admit lesser or selective charges, while serious offenses are ignored. This creates a legal gap in the historical record that diminishes the full culpability of the perpetrators. According to the case of prosecutor was Milan Simic, referring to the paragraph 50, 8 months into his trial, Simic pleaded guilty only two counts of torture as a crime against humanity. Crucially, he refused to provide the prosecution with the information for other cases, and plea agreement explicitly prevents the prosecution from using as evidence for other cases and other defendants. End quote. Now here is the problem. The counts which Simic pleaded guilty involves only 5 victims, and the prosecution withdrew the charges that affected thousands of Bosnian citizens. Similarly, in the case of prosecutors Biljana Pasvic, her plea admission were simply limited to the 5 pages, which is charge of persecution. In contrast, charges of genocide and crimes against humanity, exterminations, killings, and deportations were dropped according to paragraph 282, which creates a false impression that those crimes never occurred in the view of those crimes never occurred in the view of historical record and the public. The accompanying document in this case was only 5 pages long, provided the bare bone narrative instead of full trial that would have generated the 100 pages of trial records, witness statements, and forensic evidence and crimes in photographs. This clearly demonstrates the plea bargaining mechanism may allow perpetrators to escape full responsibility. In the process, historical record may severely compromised. My third assertion: plea bargaining often prevents the full truth from being revealed and leaving the critical details of the crimes undisclosed. In the case of prosecutors Mohamed Nicolas, the rare instances of victim participation reveal what is systematically absent in plea bargaining. During the sentence hearing of Mohamed Nicolas, a survivor named Abiba Ajij stepped outside a traditional witness role to directly confront him, pleading to know the location of her son's remains. I'm repeating, pleading to know the location of her son's remains. Only then did Nicholas provide the details about their executions and the burial sites. This powerful movement of truth-telling was not a product of this system, but occurred despite being driven by the victims' brave initiatives. Several aspects of plea bargaining seriously impoverish the search for world truth. The trial chambers itself admitted the prosecutor's Mohamed Nicolas, referring to the paragraph 65. In the cases where allegations are withdrawn, public record established by that case may be incomplete, as the public will not know whether the allegations are withdrawn because of insufficient evidence or they simply bargaining chip. The chambers explained that if a prosecutor enters a plea bargaining in which totality of individual criminal conduct is not reflected, or if the remaining charges fail to capture the gravity of the offences. This raises serious questions about the integrity of the justice. Moving to my next assertion, plea bargaining. Can plea bargaining truly ensure the full accountability of the perpetrators of mass atrocities? Well, there are several situations this may not be possible. Referring to the plea bargaining in the case of prosecutor Besengi Mehna, according to the paragraph 34 to 742, the facts in the plea agreement barely reflect what was stated in the indictment. While indictment portrayed him as actively planning and executing rapes and killings, the plea reduced his role to a passive observer. He was no longer liable for active actions in arming and training mobs for mass atrocities. Instead, he only acknowledged in the plea bargaining being present during the certain attacks. This illustrates a major problem with the plea bargain. It allows historical record to understand the full scope of the atrocities. My next assertion: plea bargaining fundamentally fails to serve the victim-centric justice. The Rome Statute itself recognizes the central role of victims in international criminal justice, especially in conventional trial process. Referring to the Article 15, paragraph 3, Article 19, paragraph 3, and 54, paragraph 1, subparagraph B, and 53, paragraph 1, subparagraph C, requires the prosecution, pre-trial chambers, and the trial chambers to consider the views and concerns of the victims at every stage. Plea bargaining, however, is structurally an agreement between only two parties. Therefore, it ultimately excludes the stakeholders. Reduced charges are distorting the fact for sake of efficiency, silence the victim's rights to truth, rights to recognition, rights to justice, which is precisely what Rome State was designed to protect the victims. From victims' perspective, a secret or behind the closed door negotiation between prosecution and the defense only raises questions about whether real justice has been done or not. This concern was reiterated in the case of prosecutor Mohammed Nikolic in paragraph 62, where tribunal recognized that plea bargaining by avoiding a full trial denies the victims' voices. Structurally, preventing the victims from actively participating in the plea bargaining process, therefore, raises the great doubts about the legitimacy of the plea bargaining. In other words, if justice is really meant to heal, then it first listen to those who suffered. At the plea bargaining, shut the victims out of the process entirely. In Bilena Prasovic's case, which was already mentioned, this case, despite a position very top at the ethnic cleansing campaign, her entire factual admission was reduced to mere 5 pages. In the prosecutor was Darko Mirza, who is the responsible for massacre in the region of Parachansky Triane. He pleaded guilty without ever being compelled to reveal the burial sites of 200 executed men. When he walked away with a lenient 10-year sentence, the victims group, women from Port Jaya region, publicly declared, open quote, the victims have not found peace even after 12 years because not even 1% of the victims from Botanoc region have been found. Now think about what plea bargaining really means to the victims. For instance, referring to the Prime Minister John Kammanda's case, whose crimes affected thousands of victims at the plea bargaining, remains more vague, providing survivors with no acknowledgement, no recognition, no answers. With reference to the paragraph 51 to 52, in this case, he showed no regret and sympathy for the victims, even when judges gave him a chance to do. Let me bring in a contemporary voice from Bosnia and Herzegovina. The president of Republika Srpska, Slobodan Zupan, recently stated, all victims must be treated equally before the judiciary. Each one deserves the post-mortem truth and justice, but not in the case of Bosnia and Herzegovina. The clearest example is massacre of Srebrenica. This is a powerful reminder that when some atrocities are protested, some atrocities are prosecuted, and some other minimized, victims are divided into two groups, those who recognize and those who are not recognized. Slobodan asked the haunting question, open quote, are the second-class victims? End quote. Absolutely no. Some crimes are addressed in open court, while some are set aside in the name of efficiency. The result will be selective recognition, selective truth, and ultimately selective justice. This is why plea bargaining is such a problem in ICLS, in international criminal justice. Therefore, it clearly establishes the opposition assertion that plea bargaining does not serve the interest of victim community. It reduces the atrocity to negotiated paperwork. The side opposition strongly asserts that if anything greater than law is, it is the will of the victims. Unless justice honors that will, law itself becomes the empty promise. In conclusion, plea bargaining in international criminal law may save the court times and resources, but it comes with a cost. It undermines the full accountability, truth-seeking, distorts the historical record, deprives the victims' voices and recognition. Therefore, it's a definitely a clog in the wheel of justice. International criminal law procedure that serve not only law but also cause of justice and humanity. With this, I rest my words. Thank you.
Thank you so much, Ganesh Bashparu, for that revealing speech. We are nearing the end of the debate, and it has been a very interesting debate so far. I'm now calling the last speaker of the proposition team, CAJPHR McLean, to present the concluding arguments of your team. Go ahead.
Today's chairperson, the panel of judges, negators, and my fellow affirmers. My name is CAJPHR McLean, a student at Ceasor University. And in line with my two affirmers, I'm also emphasizing that plea bargaining is not a clog in the wheel of justice, but rather it serves as a tool for efficient case resolution, and it is approached with caution to uphold the principles of justice, fairness, and accountability. The International Criminal Court has emphasized transparency, victim rights, informed consent, consistency, and safeguards against coercion as a solution to enhance the legitimacy of plea bargaining as a tool for achieving justice while maintaining the integrity of its legal processes. While the negators claim that plea bargaining is a clog in the wheel of justice, we affirm that plea bargaining is actually not a clog in the wheel of justice. Negator 1 gave a view that it is not a necessity of the International Criminal Court, meaning plea bargaining undermines justice. But it is important to recognize that plea bargaining results in more quick and convenient justice for the victims. To note is that the court system is overwhelmed and the trials can take years to conclude. For example, the case against former Liberian President Charles Taylor, who was charged with war crimes and crimes against humanity for his role in the Sierra Leone Civil War of 1991 to 2002, the entire process from indictment to conviction took nearly a decade. So imagine waiting for a decade for your case to come to a conclusion. Plus, the International Criminal Court handles all ranges of situations involving allegation of war crimes, crimes against humanity, genocides, among others, across countries. There are 125 countries that are parties to the Rome Statute, which established the ICC. So imagine all the 125 countries had international criminal cases, and it is only one court that is supposed to handle all those 125 cases in time. Don't you think it would be a difficulty? So the International Criminal Court established mechanisms such as independent review boards to evaluate plea bargaining agreements and ensure they are all in line with the principles of justice and accountability. Negator 2 gave a view that it leads to inconsistent sentencing or lenient sentencing. But however, plea agreements often based on established plea agreements are often based on established guidelines like legal frameworks, judicial oversights, prosecutorial discretions, defendants' rights, transparency, accountability, and cultural sensitivity. And then they have also precedents like case law. Take an example, the case of Santabello versus New York, the case of 1971. Court held that when a pre-agreement is made, it must be honored by the prosecution, and it highlighted that plea bargaining, when conducted properly, ensures fairness and accountability. Thus, plea bargaining cannot be a clog to the wheel of justice. Additionally, the judges typically review and approve plea deals, ensuring that they align with legal standards and the interests of justice. Negator 2 also gave a view that victims are often left out in the process of plea bargaining. Whereas it is important to note that very many jurisdictions have implemented victim impact statements and other mechanisms like victim participation rights, victim representatives, consultations, and assessments, so that their perspectives are also considered during the plea negotiations. Prosecutors also work closely with victims to explain the plea processes and seek their input on potential outcomes. More so, the defendants have access to competent counsel who can provide informed advice about the implications of accepting a plea deal versus going for a trial. Their counsel must make sure that the victims understand the evidence and they understand that the outcomes are fair. Therefore, plea bargaining cannot be a clog in the wheel of justice. While the negators criticize plea bargaining that it coerces innocent defendants to plead guilty, that was a view of negator 2. We, the affirmers, say the defendants still retain the right to a fair hearing or a right to a fair trial under the international human rights law. In most cases, the defendants actually opt for plea deals because they think they may face overwhelming evidence against them or believe that there is a reduced sentence. But Article 65 of the Rome Statute provides that an accused person may accept criminal for the crimes with responsibility which he or she is charged. And in the case of North Carolina versus Alford, the case of 1970, court held that the defendant could plead guilty while still maintaining their innocence if they believe that pleading was in their best interest, given the evidence against them. Plea bargaining cannot be a clog to justice because it coerces innocent defendants like the negators claim, because the defendants have informed consent and they understand the terms of the plea agreement, including consequences, before agreeing to it. Plea bargaining also serves as a tool for ensuring that cases are resolved without the need for lengthy trials that could worsen inequalities. The legal community rather addresses the systematic issues and ensures that all defendants, regardless of their background, are treated fairly in the plea bargaining process. Although the negators have a view that plea bargaining erodes public trust in the justice system, we claim that plea bargaining is a shortcut and it actually enhances confidence by demonstrating that the system is capable for efficiently resolving cases. Plea bargaining resolves backlogs and allows courts to focus on more serious cases. The notion that plea bargaining encourages criminal behavior by providing an easy way of getting out of jail is actually misleading, like the second negator said. The reality is that plea bargaining deals involve admitting guilty and accepting consequences, which can still carry significant penalties. In conclusion, while there are varied concerns regarding the practice of plea bargaining, it remains an essential component of the criminal justice system that serves various practical purposes. The International Criminal Court can enhance the legitimacy of plea bargaining as a tool for achieving justice while maintaining the integrity of its legal processes. I beg to submit.
Thank you so much, Kirsha McLean, for delivering your team's final position. We have now come to the very last speaker of today's debates. I would like to call on as the third and final speaker of the opposition team, Jean Chu Ven Katamaran, to conclude the debate for his team. Go ahead.
All right, am I audible?
Yes, you are audible.
Thank you. Good day to the esteemed judges, my honorable participants, and everyone in the audience. I'd like to begin my speech in 3, 2, 1. Great. So I'll be structuring my speech in the following manner. Firstly, I'll be making 2 clarifications, which will serve as rebuttals to the opposite side. Next, I will be moving on to summarize the arguments on my side, and thereby implicitly rebutting the arguments of side proposition. And so with that, I'd like to begin. So I'd like to make 2 clarifications, like I said earlier. The first is that the second negator never said, as Speaker 3 of the proposition claimed, that plea bargaining promotes criminal behavior. This was not a statement that was uttered by us, and this is not an inference that we wish to make directly anyway. And the second assertion, the second clarification that I'd like to make was that we will not be entering into a debate, as highlighted by the Honorable First Speaker of the side proposition, of the jurisdictional issues of the ICC, because for the simple reason that they will affect conventional trial procedures and plea bargaining uniformly. And as such, they are not the scope of the debate. So with that out of the way, I'd like to begin our summary. So essentially, the way we've gone about our debate is that we have centered our entire set of arguments around a central assertion, which is that plea bargaining is a clog in the wheel of international criminal justice because it is incompatible with the current framework of international criminal law. And we have done this using 4 major arguments. And the first one is that plea bargaining worsens the issue of disproportionate sentencing in a system where the existing punitive sanctions are already seen to be lenient. And this has certain worrying implications. Primarily, that sentencing through conventional trial possesses an educative function, which has 2 benefits. One, which is the fundamental principle of deterrence. And this would deter or make future possible perpetrators think twice before committing crimes or acts that may attract penalty under the statute. And the second, which is allowing participants in atrocities who escaped prosecution to reflect on the horrors of their crimes, as persons who have committed the same crimes as them are on trial in full public view. Plea bargaining undermines both of these. It gives you it ensures that more lenient sentences are imposed, which reduces deterrent effect, and it also, since it is fundamentally a closed door agreement, the airing of trial in a full public view essentially does not occur beyond sentencing. And second argument that we made is that plea bargaining distorts the historical record. And for this, I'd like to harken back to Prosecutor versus Bisengi Mehna, which my honorable second speaker had proposed. Here, I'd like to focus on charge bargaining. Where charge bargaining in this case reduced Bisengi Mehna from the main instigator of mass atrocities and perpetrator of rape to a passive observer whose main basis for conviction was his inaction to prevent the commission of those crimes. And this therefore leads into our third argument and a related argument, which is that plea bargaining undermines truth-seeking. And this is because the plea bargaining mechanism fundamentally has worrying incentives for both sides of the agreement. And these constitute 2 major obstructions to justice. Firstly, from the side of the defendant, it incentivizes the embellishment of facts, as the defendant is incentivized to embellish facts to ensure that his testimony is perceived to be of higher utility to the office of the prosecutor. And this was clearly seen in Prosecutor versus Nikolic and Prosecutor versus Babich from the ICTY, where both Nikolic and Babich admitted to lying or otherwise embellishing facts in their statements or to their prosecutor in hopes of getting a more lenient sentence. And the worst part about this entire thing is that there is no way to ensure that such cases don't repeat again, or indeed that they have occurred before and gone unnoticed, since there exists no stringent, comprehensive, corroborative framework for checking this information that's provided by the defendant. And I'd like to cite Prosecutor was Nikolic for this as well. And this leads into the second issue, which is from the side of the OTP. The OTP was not interested in answering the question of the objective factual correctness of information. And this can be clearly seen in Nikolich's case, where the prosecutor requested the court to go by the admissions that Nikolich had delivered in his plea agreement, in case there were inconsistencies between the plea agreement and what he had stated in court. And the court readily accepted this explanation. So clearly, there was not enough effort put into finding out what actually happened, but what was taken into precedence was rather what Nikolich says happened. And so clearly, at some point, this devolves from finding objective factual truth to taking Nikolich by the weight of his words. By taking a person, I'll repeat, by taking a person who's acting in a vested interest in order to obtain a lenient sentence by the weight of his words. And therefore, the adjudicating system in case of a plea bargain is not interested in uncovering information not directly relevant to building a case of guilt on the perpetrators at the very least. And this has been clearly highlighted by my second speaker when he brought about Nikolich's case, because it took a witness to move beyond her traditional role as witness to confront Nikolich in open court to obtain information about her dead son's remains. This was something that the OTP would simply not have expounded their resources on or spent their resources on, as it would not directly help in prosecuting the leech. And clearly, this impairs the historical record, as we stated earlier. Now, as I've summarized the main arguments that we've made, I'd like to move on to some constructives, as I still have quite time left. And the first argument that I'd like to make is plea bargaining is a roadblock in the reconciliation process. And this argument is simply a summary of what we've made so far, which is plea bargaining disrupts the educated function of a conventional trial sentencing, and through charge bargaining allows modifications to the historical record, distorting the actual truth of the atrocities, as I have just stated. And it leaves room for propagandist revisionist interpretations, which is diametrically opposite to the aim of reconciliation, as international criminal justice, as one of international justice aims, happen to be. And the next point that I'd like to make is that plea bargaining is structurally inherently coercive. And I say this not just because of an informational differential between the OTP and the defendant, but also because of many other factors, such as a psychological burden being only on one party in the agreement, which is the defendant, because he is the only party in the case with a sword of sanction hanging. And the OTP is often a structuralized institution in and of itself, while the defense counsel is not so, consists of an individual or a bunch of individuals working to defend the defendant. And second, I'd like to thank the honorable third speaker of the proposition for bringing this up, which is that the defendant has a right to a fair trial. And this in plea bargaining is faced with a fundamental roadblock, which is the trial penalty. The penalty for exercising one's right to a free and fair trial. Because here, justice in a plea bargain is reduced to a cost-benefit analysis, which is also something that speaker number 3 of the proposition had indirectly said as a result of this. And in this case, in the case of a plea bargain, the defendant weighs his options. If he is likely to be sentenced in a conventional trial hearing, he opts for a plea bargain. However, if the evidence mounted against him may not amount to a conviction, he might go for a conventional trial proceeding, thus dragging the proceeding further and expending resources of the court, which again is which happens to be the main thrust of the proposition's argument. And I'd like to go to my final argument here, which is that plea bargaining is not a functional necessity for the ICC. And Scharf, in his seminal paper, Trading Justice for Efficiency, makes a very interesting argument. He analyzes cases from the ICTY, specifically the genocide cases of the ICTY, where it was clearly shown that for every single case that involved a charge of genocide, the same experts put forth the same information and the same victims recounted the same testimony in several cases to prove that what happened in the former Yugoslavia was not just an international armed conflict, or what happened in the certain cases regarding the atrocities was not just an international armed conflict, but a genocide. And therefore, Scharf proposes that if the International Criminal Court introduced an amendment where substantial facts proven in previous cases were carried forward to subsequent cases, that would solve a great deal of the burden on their resources. So it's not that plea bargain is the only alternative that exists for ensuring ICC efficiency. There are other mechanisms that exist, and there are other mechanisms that will come up in the future as well. And with that in mind, I'd like to summarize what a world with plea bargaining would look like. A plea bargaining in a world with plea bargaining, we would have non-genuine confessions, as shown in Darko Miyaza's case, where he does not mention the murder that he has done. In Nikolich's case, where he completely deflects his blame, and in Darko Miyaza's case, where he paints himself as a heroic peacemaker. And honestly, at this point, the side proposition does not see the difference between efficiency in through plea bargaining and the obstruction of justice. With that, we would like to rest arguments.
Thank you so much, Jinshu Venkataraman, for your sound final speech. This concludes the debate part of the session. I am now asking the judges to join the breakout room to reflect on the debate. For our audiences and for the participants, you can take a 15-minute break. So it's right now 12:57 European time, so see you in 15 minutes. And if you are coming from another base, just come back in 15 minutes. Thank you. Is everyone present? So I'm just waiting for the two teams to come back. I just need a yes by.
We are here. We are here.
You're here? Okay,
Yeah.
Okay, perfect. Then I'll start. So, welcome back, everyone. I hope you had a very eager to all hear from the judges. Now, I would like to invite Judge Sally, Judge Abidina Shiru, and Judge Jean-Yves Ndenza to give their final feedback and decision on the debate. And also, you can say a few words to the students aspiring to be renowned legal professionals and international law expert in the near future. I'm now going to give the floor, first of all, to Judge Sally for her to give on her comments and also on her, I think, points. And yeah, go ahead.
Thank you, Anna, and thank you to the teams that have been debating today. You did a very good job, and you really made very good arguments on both sides. I'd like to start with the team from Ceasor, King Ceasor University, who was supporting the plea bargaining in the international scene. You did a very good presentation. I love the way you presented. You were very smart. Your demeanor was very good, which is very important in cases like this. How you present your case, how you introduce your team, and how eloquent you are. I just wish you had delved a bit deeper. I felt like in your discussions, you're staying on the periphery of your discussions, and that could have affected your presentation. But all in all, thank you very much. And the Indian team led by Kushi, you had a very good presentation. Thank you for that. You were very smart, eloquent, and you really grasped, you had a good grasp of your topic. I also want to commend the last speaker on the opposition. I didn't get his name. Very confident. Thank you for that. And also Rapu, you made a very good presentation, and for you were very passionate about your submissions, and you referred to cases. I think when you're arguing your side, always try as much as possible to refer to the law applicable and to present as many cases as possible, just to give the court and the judge enough background and history into what you're speaking about. All in all, thank you very much. Well done. It was a very exciting debate. I wish you well, and please remember that it's not just about winning, but at the end of the day, it's about your passion for the topic, your passion about the law. So my marking, according to what I heard, for the first team, I awarded 52, and that is the African team. And for the Indian team, I awarded 48. Very well done. Thank you.
Thank you so much, Judge Ariet, for your comments and your help as well. We're gonna go into, I'm gonna give the floor to the second judge, which is Jean-Yves Nzana, to bring on his comment, his grading, and any other details he has to add. Go ahead.
Okay, thank you very much, guys. And sorry because I had to move quickly. I told Ines that today it's a crazy day for me. But nevertheless, first, I'm really happy to meet Sophia again. Ines didn't know that I knew Sophia. So we discussed, she didn't know
Really?
that I
didn't
know
know about
Sophia.
this.
Yeah. So it was really a pleasure for me meeting her again. And coming back to our topic today, I was really, really impressed. And also, I learned a lot from you guys, especially coming from the younger generation. I can see already the potential. I can see the grounds and the capacity for future lawyers, for future decision makers, for future policy makers as well. And I really like the arguments you made. It's not about winning or losing, as my predecessor said. It's about really trying to make an argument and to make your voice heard. So what I like with the African team, if I may call it like that, is that in the beginning, I really like the confidence that the first presenter demonstrated. And I might be wrong, but I felt like she wasn't really. As a diplomat, I'm more used to negotiating, to bargaining, and to speak. Like you discuss with somebody and you look at him straight in the eyes. It shows confidence. It shows that you mastered the topic. And also, I like the very fact that she could, let's say, bring theory and practice together. When she mentioned, for example, the case of Omar El-Bashir, that was very scientific as it was demonstrative. Her peer colleagues did the same, but where I was a little bit still starving is I felt the main argument was more about logistic. It was more about like we don't have we have only one building or one institution that could be dealing with 2,000 crimes. It's not possible. So from that perspective, plea trial can be useful. Yes, of course. And don't get me wrong, you're right from that perspective. But from the legal and humanitarian perspective, it's not a very solid argument in the sense that, okay, if perpetrators want to fly away from their duties, they should just perpetrate it in so many areas, and that will be it. That was the kind of dark point I noticed with the African team. With the Indian team, I think it was Koshi the first that had the floor. I was really astonished, honestly. Like I felt like she just waited for Ines to press on the button on. And she was like, "Da, da, 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 and you know this, and you know that, and you know this, and you know that." And this tip you all had to do like I'll be speaking in 3, 2, 1, go. I also like it because it showed that you were setting the timing, you were setting the pace, the pattern, and everything. So that was a very good point. I also like the third speaker from the Indian team because he was very attentive, and he clarified all the points that had been either misunderstood or that were not right understood. Let's put it like that. On those basis, I decided humbly that the African team will be awarded 48 and the Indian team will be awarded 52. Those are my humble comments about it. And last but not least, I will share with you my LinkedIn profile because, as I said, it's not about winning or losing. It's about learning. It's about sharing our experience. So if anyone would like to discuss further, you need maybe some orientation, you need some documentation, or you need anything like that that I will be or I can provide. Please do not hesitate. I just mentioned it here in the Zoom comments. Do not hesitate to get in touch with me, either from Uganda, from Africa, for wherever you are. Just get in touch with me and let's work on something because I'm really, really, let's say, eager to help the younger generation to have the knowledge tools to deal with certain issues. So that's my LinkedIn profile, and the best is always to come. So do not hesitate. Thank you.
Thank you so much, Naif, for all of your really nice comments and your help. I'm now going to give the floor to Judge Abiodun Ashiru, and after this, we're gonna deliberate on who's the winner and the total points for both of the teams. Go ahead. Judge Abiodun Ashiru, you can go ahead.
Ines, I think he has some technical problems because I cannot see him as a participant in the meeting.
Okay, that's fine because he was in the room deliberating with the other judges. Should we wait just 5 minutes the time he comes back, or? So wait one moment. We're just gonna call him and coming in a second, I think.
Ines, you can just go ahead and read Mr. Ashiru's points since I think we lost connection with him. Please go ahead.
Okay, sure. So, just regarding the comments of Abiodun Ashiru, he said that both of the teams were really good, very excellent as well. Of course, it's just a few points I believe that you need to work on if he comes by the meeting, or if we have a hold of him at some point, we will send you the comments he said, and we will transfer it to both of the teams. However, he also shared his point. So, Abiodun Ashiru gives to the African team 40 points, while for the Indian team, he gives 60 points. So both of those points with the three judges basically calculates for the African team so as 139. So Jean-Yves gave 47, Judge Ariad gave 52 points, and Abiodun Ashiru gave 40 points, which resulted at a result of 139. And for the Indian team, Jean-Yves gave you a point of 52 points, which you calculate on top of that the 48 points of Judge Ariad and the 60 points of Abiodun Ashiru, which gives a total result of 160 points, which means that the winner for today's debate on the plea bargaining in criminal justice is the Indian team. Congratulations.
Congratulations.
Thank you so much. We'd also like to thank the other team for giving us a very competitive engaging.
So before closing remark on this meeting, I would like to give the floor and invite Mrs. Adesola, the Executive Director of the Center, to deliver her closing remarks. Once again, thank you so much for both of the team commitments. You did amazing. Regarding the team that won, congratulations, you deserve it. And the other team, you did an extremely really good debate. I was present in the debating room, and it is very true that it was quite a close fight, I would say. So congratulations to both of you, and remember that it was an opportunity to gain experience, to work on your rhetorical skills. And once again, thank you so much for attending and your commitment. I will now give the floor to Mrs. Adesela.
Thank you very much, Ines, for your remarks and for moderating so beautifully. As always, so appreciative of all your effort. As she has said, my name is Adeshola Adebojo, and I'm the Executive Director of the Center. I really want to appreciate everyone who's been part of this event. It's been awesome. We have now concluded the event, and I want to thank the judges, Judge Harriet Sally, Judge Jean-Yves Nzana, and Judge Abiodun Ashiru for the amazing job that they have done, for their remarks, their assessment that has been so incisive. And I'm sure that the debaters have taken on board the points that they have made, which they would carry forward for their future in terms of their debating skills. I also, of course, want to appreciate the coaches who have taken time to prepare them for this debate. Reverend Counsel Samson Malis and Dr. Rajat Banerjee, thank you very much for this wonderful work of guiding the debaters for everything that they have done. And of course, the debaters themselves, they've put in everything. They really gave it their all. And even though the Indian team has emerged the winner, I know that we can all say that we have had a truly fierce debate, and all of us have left this session better informed about both sides of the debate in terms of plea bargaining. So thank you very much to the debaters. Thank you for all the work that you put in, and thank you for doing such a marvelous job concerning the topic. I also want to express my gratitude to all our audience from all over the world. I was following on YouTube in the early part of the debate before I joined on Zoom. So I know that even those who haven't watched now would probably still watch later on YouTube. So I want to appreciate everyone. I want to appreciate our timekeepers. I want to appreciate the technical team. And of course, the other members of the center's board members who have also ensured that this has been a wonderful debate. We are very grateful as a center for all your contributions. And I want to thank Anna Maria, who was representing the founder of the center, Ms. Sophia Ugu, for all the work and for her excellent opening remarks. And of course, we cannot fail to appreciate the founder, Ms. Sophia Ugu, for her support and guidance and everything that she has done to make this an excellent outing. As always, we are truly grateful. We hope that we're going to see more universities collaborating and coming in future for other debates. We always have an excellent time when we have these debates, and we're looking forward to more of it in future. Lastly, I want to appreciate everyone again to say that we hope also we are going to get more contribution from everyone when next we call upon you to be part of our debates. I've been asked to request all of us to follow our social media pages before you leave this session, and also, of course, to make sure that you send our links out there to your contacts. All the links to our social media pages are shown on the screen or attached below under the video. And I'm hoping that we will all do the needful. That will be all for today. Again, I hope you've enjoyed it as much as I have, and I hope that you enjoy the rest of your day. Thank you very much.
Thank you, Ms. Adesola, for joining today. Thank you for all your nice words. I just wanted to tell the debaters that you will receive a certificate award in the incoming weeks. And also, we will be presenting a small gift to the two teams as well.
As well, just another point I have to do very quickly. So Abidula Shiru tried to get back in the meeting, but there's an issue with his network. I just received back his answer. So it's just that unfortunately he cannot come in. So we'll receive at some point his comments directly. I will transfer them to you if you want to be able to know like the best expertise on the topic. And yeah, go ahead now.
That was all for me as well. We can wrap this up. Thank you very much, guys, and let's keep in touch, of course.
Thank you very much for your time and your patience and your rhetoric and your talent as well. And have a lovely day ahead. Thank you.
Thank you.
Thank you, everyone. Bye.
Thank you.